petitions dated so and so. That no notice before termination was served upon the petitioner, asking him to submit his defense reply before the petition was passed.
As such, there is a violation of principles of natural justice.
Then counsel for the petitioner has sought to rely upon the decision of the apex court in the case of Gandhi versus so and so in support of his submission as regards requirement of compliance of principles of natural justice as it entails adverse civil consequences. Small 3. Petitioner has also, then counsel for the petitioner has also placed reliance upon the decision, upon paragraph 127 of the judgment in the case of Tanmena in order to submit that since petitioner was not a party in those writ petitions, by the principle of prospective overruling, the case of the services of the petitioner were saved. And counsel for the petitioner has therefore submitted that the services of the petitioner have been terminated in violation of principles of natural justice. So it entails adverse civil consequences. And he was not a party or covered by the decision of this court in Tanmena or before the apex court, where the judgment was affirmed. So, the writ petition is not barred by delay, as not only there is no period of limitation prescribed in writ jurisdiction for invoking writ jurisdiction, and further his services were continued till 31st March 2020. Then counsel for the petitioner has also referred to certain presentations and applications made for furnishing information under RTI before the authorities of the state which have not been heeded to. So he has also referred to certain answers obtained under RTI from the Supreme Court registry to the effect that the petitioner was not a party in the petition number so and so arising out of before the apex court arising in the case of Tanmena and others. Substance is the case of the petitioner that the case of the decision of Tanmena does not cover the case of the petitioner, and as such, the services could not have been terminated without proper show cause notice and without consideration of his defense applied. The learned Advocate General has strongly opposed it. He submits that the petitioner has not been able to make out a clear case through the pleadings of the writ petition that he was not covered by the category of selectees or teachers belonging to undergraduate, graduate, and postgraduate, belonging categories of teachers, undergraduate, graduate, and postgraduate, as have been dealt with squarely under paragraph 4.8 of the decision in Tanmena. The writ petition is an abuse of the process of law, as petitioner has failed to show as to how his case is distinguishable or segregated from the rest of the teachers whose appointments were set aside primarily on the ground
whose selection process was set aside primarily on the ground that the revised employment policy 2003, under which the recruitment exercise was undertaken under advertisements of 2002, 2009, were found to be arbitrary, illegal, and suffering from nepotism and favoritism. So it is submitted that the decision of Tanmay Nath has been rendered is a judgment in rem, and no individual teacher can claim to be accepted from the rigors of that decision, which has been confirmed up to the apex court. The petitioner can also not complain that that no notice was served upon him, as by virtue of the order dated so and so, passed in the case of 6th February 2014, passed during the proceedings of Tanmay Nath's case. Notices were issued to all such teachers through paper publication, in line of the principles contained under Order 1/8 of the CPC. Stop. And the Advocate General has also placed the decision of this court, division bench statement of this court in the case of Vijay Krishna Saha and others, where the same contentions have been raised and squarely dealt with, answered by this court. So it is submitted that petitioner has the decision in Tanmay Nath covers 10,323 teachers. Petitioner is also one of them. As such, the plea of non-compliance of principles of natural justice or opportunity to show cause does not arise in the case of individual petitioners when the entire selection process has been set aside. Counsel, Learned Advocate General has also sought to rely upon certain decisions. Sought to rely upon the decisions which have already been referred to in the previous part of this judgment. So, we have given anxious consideration to the rival submission of the parties. It needs to be mentioned at the outset that by virtue of the judgment rendered in review petition number 40 of 2023 by one of us within bracket T. Amarnath J, it has been abundantly made clear that the writ court had not granted any relief in favor of the writ petitioners for providing them any appointment or to continue with their services as teachers. Stop. The referral order dated 30th May 2023 passed in WPC number 893 of 2022 has elaborately discussed the referred to the judgments rendered by this court in the case of Tanmay Nath and others, dated so and so, Sri Vijay Krishna Saha and others, dated so and so, and also the judgment of the apex court dated 29th March 2017, whereby the case of whereby the decision in Tanmay Nath was affirmed, certain modifications in paragraph 123 of the order of the judgment in Tanmay Nath's case stuck. However, since at the fag end of the order, it was the judgment passed in WPC number 334 of 2021 was brought to the notice of the learned court. The matter was referred to Honorable the Chief Justice to constitute an appropriate bench to do the case. After hearing learned counsel for the parties at length and after giving answer to the tribal submission of the parties and the points raised, we are of the unanimous view that the issue of legality of the appointments undertaken under advertisement number of 2002, 2006 and 2009 in terms of the revised employment policy of 2003 have attained finality by virtue of the judgment rendered by the apex court in the case of so-and-so dated 29th March 2017, whereby the decision of the division bench of this court in the dated so-and-so in the case of Tanmay Nath has been affirmed. The entire selection process, the relevant paragraphs of the judgment in the case of Tanmay Nath have already been quoted here and above. The order of the apex court dated 29th March 2017 and the interim order passed thereafter by virtue of which ad hoc extensions were granted to the teachers like the petitioner to continue till 31st March 2020 have also been referred to here and above. The decision in the case of Tanmay Nath is a judgment in rem which operates as regards all the appointees, selectees under the advertisements of 2002, 2006 and 2009 and covers 10,323 teachers of different categories, that is undergraduate and youth and postgraduate, including the present petitioner. Petitioner it is not that proper notice was not issued upon all the appointees / selectees under the aforesaid advertisement, as by virtue of the order dated 6th February 2014 in the case of Tanmay Nath, notices were issued to all through paper publication in terms of order 108 of the CPC. It appears that this petitioner, despite valid notice, did not choose to intervene in the batch of writ petitions decided in the case of Tanmay Nath, nor did he approach this court earlier after the termination order dated so and so annexure 5, and continued to enjoy the ad hoc extensions to his service till 31st March 2020 in terms of the order passed by the apex court. The present case of the petitioner is not one where his services have been terminated on charges of misconduct, where the principles enshrined under Article 311 of the Constitution of India can be read in. The entire selection process was set aside as the revised employment policy of 2003 suffered from various illegalities, arbitrariness, lack of guidelines, arbitrariness, favoritism, and nepotism in the process of appointment. The learned division bench of this court had directed fresh policy to the employment policy to be framed and selection process to be undertaken. Fresh selection process to be undertaken after giving some relaxation to the appointees whose services were terminated. It therefore doesn't lie in the mouth of the petitioner to contend that the impugned termination orders dated so and so are suffering from violation of principles of natural justice, and that petitioner is not covered by the judgment of this court in case of Hanmenath as affirmed by the apex court. So, in fact, the contention of the petitioner relying upon para 127 of the decision of Hanmenath also has been squarely dealt with by the division bench of this court in the case of Vijay Krishna Shah, and the reasons are the secrets. As is apparent from a reading of para 127 of the para 127 of Hanmenath's case, it can't be read in isolation from the preceding paragraphs starting from paragraph 121, 122, and the nature of directions passed by the court contained in paragraph 123 to 126 of the judgment. So, it is quite obvious that since several employments could have taken place under the revised employment policy of 2003 concerning other departments, which were not before the court in the case of Hanmenath, within bracket, which covered the case of teachers under education department only, the learned court was conscious, the learned court consciously clarified that this decision would operate prospectively unless, as regards other appointments made, unless the judgment would operate as regards the appointments made under the advertisement dated 23rd March 2009, 23rd September 2009, unless any employment made in any other employment made under any other department was already under challenge on grounds of on the ground that the employment policy is illegal. As such, para 127 does not confer any benefit or leverage to the present petitioner to escape from the rigors of the decision rendered by this court in the said case as affirmed by the apex court. The litigation journey, as observed at the outset, has gone for almost 12 years by now, since the first writ petition was filed in the year 2011. The beneficiaries of that selection process ought to have obeyed the judgment of this court in the case of Hanmenath, and as affirmed by the apex court by judgment dated 29th March 2017, instead of raking up the issue, taking up their grievances on non-issues. This court therefore deprecates the approach of the petitioner in indulging in an abuse of the process of court once the decision of this court has attained finality by virtue of the judgment rendered by the apex court, and none of the points raised herein are such novel points which are available to be raised by the petitioner. As observed herein above, we are of the unanimous view that no interference is called for in the impugned orders, whereby the services of the petitioner have been terminated. So, the writ petition is therefore, the reference is answered accordingly. The instant writ petition is dismissed. Dismissed with a cost of 25,000 to be deposited in the state legal services department.
They are unemployed.
They should be conscious, and others also should become conscious.
Okay.